Why is mediation such a pivotal part of the South African legal system? What makes it so significant that it's become a fundamental component of the High Court Practice Act under Rule 41A? Today, we are going to delve into these questions and shed some light on the intricacies of Rule 41A. Imagine a scenario where two parties have a dispute. They could take it to court, a process that is often lengthy, costly, and stressful. But what if there was a way for them to resolve their differences amicably, potentially saving time, money, and emotional strain? This is where mediation steps in, and in South Africa, Rule 41A of the High Court Practice Act is the guiding light for this process. Rule 41A, introduced in 2020, is designed to encourage mediation as a preferred method of dispute resolution. It applies to all civil disputes, except where another law or rule provides otherwise. The rule essentially obliges parties to consider mediation before proceeding to trial, adding a layer of amicable negotiation to the legal process. Now, you might be wondering what makes Rule 41A so special. Well, it's the first time in South African law that parties are compelled to at least consider mediation before heading to trial. This change reflects a global trend towards dispute resolution methods that are less adversarial and more collaborative, a trend that South Africa has now officially joined with Rule 41A. Breaking down Rule 41A, we can identify three key components. The first is the Notice of Intention to Defend, Form 27. Notice agreeing to mediate or intoas of opposition to mediate, which must be delivered by the defendant within 10 days after the service of the summons. This notice is followed by a meeting between the parties where they discuss the possibility of mediation. If both parties agree to mediate, they proceed to the third component, the actual mediation process guided by a mediator. What happens if one party refuses to mediate? The rule provides that if a party unreasonably refuses to mediate, the court may take this into account when deciding on costs at the end of the trial. This means that refusing to mediate might have financial repercussions for the refusing party. So, to summarize, today we've explored the importance of mediation in the South African legal system and delved into the complexities of Rule 41A of the High Court Practice Act. We've learned that this rule encourages parties to consider mediation before going to trial, with potential cost implications for parties who unreasonably refuse to mediate. We've also seen how Rule 41A is part of a global trend towards more collaborative methods of dispute resolution, marking a significant shift in South African law. And finally, we've broken down the key components of Rule 41A, from the Notice of Intention to Defend to the actual mediation process. Understanding Rule 41A and the role of mediation in South Africa's legal system is crucial, not just for law students or legal practitioners, but for anyone who might find themselves involved in a dispute. It's a testament to the power of collaborative problem solving, and a reminder that sometimes the best way to resolve a conflict might not be in a courtroom, but around a table. Now let's shine a spotlight on one of the key figures behind the push for mediation and alternative dispute resolution in South Africa, Arthur Nicolason. A tireless advocate, mediator, and author, Arthur has championed the cause of mediation as a practical and efficient means to reduce the caseload on the court system. His contributions have significantly impacted the legal landscape in South Africa, helping to shape Rule 41A and the broader acceptance of mediation. His work is a testament to the power of innovative thinking in the legal field. If you're interested in learning more about Arthur Nicolason and his work, you can visit his website at www.navantubiz. His writings provide a wealth of insight into the world of mediation and its transformative potential in the realm of dispute resolution. Voiceover. In our journey to understand mediation and Rule 41A, it's important to highlight the individuals who championed its cause and brought about this transformative change. One such champion is Arthur Nicolason. Arthur is not just a mediator, he is also an accomplished author whose writings have significantly contributed to the field of mediation and alternative dispute resolution in South Africa. His tireless advocacy is aimed at reducing the caseload on the court system, thus making justice more accessible and efficient. He believes in the power of mediation to resolve disputes in a fair, impartial, and less adversarial manner. His contributions were instrumental in shaping Rule 41A, including other forms of mediation, and promoting the broader acceptance of mediation in the South African legal system. If you wish to delve deeper into the world of mediation and understand its potential to transform dispute resolution, Arthur's writings are an excellent resource. You can get in contact with him at www.navantu.biz. His insights, experience, and dedication to the cause of mediation make him an invaluable asset in this field. So, let's take a moment to appreciate the efforts of people like Arthur, who strive to make our legal system more efficient and equitable. Personal style. He has garnered much acclaim for his love to help any human being and any organizations to resolve disputes. What set Niklason apart from other mediators with his 30 years experience in this field, he brings his debt counseling and mediation expertise with love and passion for this game. Niklason is not only radical in resolving dispute, but very aware of a conscious balance and the right to dignity, but he believed that dignity violations and indignity were supposed to be dead and buried many years ago. He does not believe, even though in some instance some parties wish to come to a session with authority, the financial muscle. His goal is always one thing in mind, and that the parties are key and they need to engage, resolve issues. For this reason, he ensures that his mediated matters only goes to court for settlement endorsements. The court is the last door. He further believes that it is at the very same courts where dignity violations occur on a daily basis. I set out below are a small selection of comments received direct from parties who have appointed Arthur as mediator. Further examples can be found on his biography on the website link here.